Welcome to Module 4, International Crimes and State Enforcement. I am Professor Rashmi Raman and I will be taking you through this module. The learning objectives in this module are to understand what constitutes an international crime and to understand what are the types of international crimes. Thirdly, this module also teaches you how to protect the sovereignty of a state and how to prosecute international criminals, to understand when a crime has universal jurisdiction that we spoke about in the last module, to learn about extradition and how it works, to learn about the Interpol and its duties and responsibilities. Under this module, we will be dealing with the following topics. Types of international crime, sovereignty versus international criminal law, universal jurisdiction in criminal law, the law of extradition, and the organization known as Interpol. There are 5 types of international crimes. 1. The prohibited conduct affects a significant international interest, in particular if it constitutes a threat to international peace and security. 2. The prohibited conduct constitutes an egregious conduct deemed offensive to the community of shared values in the world, including conduct deemed shocking to the conscience of humanity. 3. The prohibited conduct involves more than one state in its planning, preparation, or commission, either through the diversity of nationality of its perpetrators or victims, or because the means employed transcend national boundaries. 4. The conduct is harmful to an internationally protected person or interest. And 5. The conduct violates an internationally protected interest, but it does not rise to the level required by 1 or 2. However, because of its nature, it ought to be prevented or suppressed. The types of international crimes are, firstly, genocide. Genocide means any of the following acts committed with an intent to destroy, in whole or in part, a national, ethnic, or religious group as such. Killing of the members of the group, causing serious bodily harm or harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children from one group to another. The Genocide Convention deems punishable genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempts to commit genocide, and complicity in genocide. It provides persons committing genocide or participating in any way with the act of genocide that they should be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. Neither the IMT or the International Military Tribunal for the Far East recognize genocide as a distinct crime vis-a-vis crimes against humanity. However, today, the crime of genocide is clearly distinguishable from the crime known as crimes against humanity. That is because both of them have separate and discrete elements. Genocide is defined by the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. The Genocide Convention, including the classification of genocide as a crime under international law, are now considered to be part of customary international law. This means that these laws are binding on all states, irrespective of their membership of the Convention Against Genocide. Genocide means any of the following acts committed with an intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. War crimes. Article 227 of the Treaty of Versailles, 1919, spoke of war crimes for the first time. Article 6b of the Charter of the International Military Tribunal introduced the word war crime into international treaty law. It defined war crimes as violations of the laws or customs of war, including but not limited to murder, ill treatment, or deportation to slave labor, or for any other purpose of civilian population of or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns or villages, or devastation not justified by military necessity. This definition, in part and in whole, remains replicated today within the statute of the ICC. Article 8, Clause 2 of the Rome Statute was the first to codify war crimes. This definition is only helpful for assessing crimes over which the International Criminal Court has jurisdiction. It lacks general application. In order to be characterized as a war crime, the prohibited act or omission must be committed during and in connection with an armed conflict. War crimes can now be committed both as part of an international or a non-international armed conflict, the so-called NIAC. The legal consequence of a conflict being characterized as international or non-international is extraordinarily significant, since the rules governing internal conflicts are fewer in number and provide less protection to the parties involved in the conflict. However, the rules protecting individuals in war crimes in international armed conflicts are far more complicated. According to Article 8, Clause 2 of the Rome Statute, war crimes mean 1. Willful killing, 2. Torture or inhuman treatment, including biological experiments, 3. Willfully causing great suffering or serious injury to body or health, extensive destruction and appropriation of property not justified by military necessity, and carried out unlawfully and wantonly, compelling a prisoner of war or other protected persons to serve in the forces of a hostile power in the course of hostilities, willfully depriving a prisoner of war or other protected persons of the rights that they are assured under their constitution of a fair and regular trial, and finally, unlawful deportation or transfer or unlawful confinement. This also includes the taking of hostages. War crimes are distinguishable from crimes against humanity in two important respects. Firstly, war crimes can only be perpetrated under an armed conflict, whilst crimes against humanity can be perpetrated at peacetime as well. This distinction was made very clear by the Special Court for Sierra Leone in the Charles Taylor decision. An act to be classified as crimes against humanity must be widespread or systematic, but a single act or omission can qualify for a war crime so long as it is connected with an armed conflict. The Special Tribunal for Sierra Leone in the Charles Taylor case further expounded on the distinction between armed conflict and non-international armed conflict. Crimes against humanity. The atrocities committed by the Nazis during the Second World War were the reasons for the first international formal recognition of the concept of a separate crime known as crimes against humanity. The then existing definition of war crimes, which was conceived of during the international military tribunals, did not cover the Nazi atrocities. People felt that Nazi criminals should not escape punishment only for the lack of a clear definition. Therefore, Article 6, Clause C of the International Military Tribunal's Charter provided for specific jurisdiction over crimes against humanity. According to this definition, crimes against humanity, known as CAH, came to mean any of the following. When committing acts that are committed as part of a widespread or systematic attack. In this definition, widespread and systematic are both important, but what is more important is that they are separated by an or. Therefore, it is not together, but one or the other. A widespread or systematic attack directed against any civilian population with knowledge of the attack. Under the following heads: murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, but not to the extent covered by the Torture Convention, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced disappearances, sterilization, or any other form of sexual violence of comparable gravity, persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, or gender grounds. Enforced disappearance of persons. This became extremely pronounced in Latin America. The crime of apartheid, reminiscent of course of the South African apartheid, other inhuman acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health. Sovereignty versus international criminal law. Jurisdiction refers to the power of each state under international law to prescribe and enforce its municipal laws with regard to persons and property. This power is exercised in three forms: legislative or prescriptive jurisdiction, judicial jurisdiction, enforcement jurisdiction. Interstate commerce and the movement of people has increased significantly since the 18th century, when these laws were written. Until recently, there did not exist even a general set of rules delineating conflicts of criminal jurisdiction. These came to be subsumed under the general head of conflicts of law. The conduct occurring solely on the territory of one country could logically fall within that country's competence. The application of the general rule, whereby a state may unilaterally lay claim to jurisdiction in a particular case with the sole proviso that no other state or rule of international law is opposed to it, creates further conflicts. It is only now, with the creation of international criminal law, that these fundamental and classic rules of jurisdiction have been challenged. There still does not exist a general agreement resolving issues of concurrent criminal jurisdiction. Problems of concurrent legislative jurisdiction, and in particular in criminal matters, are satisfactorily dealt with only where they have been regulated by treaty. These are the instances where codified law makes it amply clear what the intention of the states has been at the time of entering into the treaty. Even where specific conduct has not been regulated by treaty, jurisdiction cannot be said to constitute a settled matter, since not only non-state parties might oppose the said rule, but also states parties may disagree over its ambit, execution, or hierarchical status. This leads us to the next part of the development of jurisdiction, which is the creation of universal jurisdiction. Under universal jurisdiction, in international criminal law, any state may assert its authority over offenses subject to universal jurisdiction. Due to the broad extraterritorial competence encompassed by the exercise of the principle of universal jurisdiction, it is reasonable that only a very limited number of offenses can be subject to the application of this principle. Crimes under international law, which are known as international crimes, have customarily not been subject to universal jurisdiction. Only since the creation of the jurisprudence in Augusto Pinochet's case have international crimes attracted universal jurisdictions in two independent ways, based on the heinous, repugnant nature and scale of the offense, as is the case with grave breaches of humanitarian law and crimes against humanity, on the inadequacy of national enforcement, such as crimes committed on the high seas. The fact that an international crime does not attract universal jurisdiction under international law does not necessarily mean that it may not attract universal jurisdiction under national law. This works by the extraterritorial application of human rights treaties. It encourages parties to assert expansive jurisdiction with respect to offenses contemplated under national courts. National courts have traditionally upheld the universality principle with regard to crimes. A great example of this is a number of states that have today signed various human rights instruments and seek to enforce them by extraterritorial application. Crimes defined under municipal criminal statutes for a number of offenses, such as war crimes, crimes against humanity, and genocide. Extradition is the formal process whereby a fugitive offender is surrendered to the state in which an offense was allegedly committed, or in which an offender was said to have a proximal nexus. In order to stand trial or to serve a sentence of imprisonment, states resort to extradition treaties. There is no general rule of international law that requires a state to sign extradition treaties or to surrender fugitive offenders to each other. All of this is done based on formal treaties or on rules of customary international law. Mostly, these are reciprocal rules between states, with some notable exceptions. But the rules of customary international law that created extradition have since been honored and recognized even in the absence of treaties. The United States, for example, has entered into extradition treaties with various states. Even though extradition is traditionally founded on the concepts of reciprocity, comity, and respect for differences in other jurisdictions, the absence of an effective extradition agreement can result in law enforcement agencies using extrajudicial and irregular forms of extradition. A powerful example of this was illustrated by the case brought by the United States against Mexico before the International Court of Justice. Most modern extradition treaties seek to balance the rights of the individuals with the need to ensure the extradition process. For the extradition process to operate effectively, it has to be based on principles that are now regarded as established international norms. These are designed not only to protect the integrity of the process itself, but also to guarantee the fugitive offender a degree of procedural fairness under due process. These principles must include, therefore, the requirement that the fugitive has committed an act which is an extraditable offense. This, in turn, must be linked to the principle of double criminality, the rule of speciality, the political offense exception, the restriction on return or non-refoulement for military and religious offenses, and this does not include, of course, refugees, the prohibition on return in death row cases, and the principle of double jeopardy. All of these are commonly recognized common law principles that occur in constitutions. The final part of this module is an introduction to the organization known as the Interpol. The Interpol is the world's largest international police organization, operating worldwide with over 186 member states. Its headquarters, known as the General Secretariat, are located in Lyon, France. Interpol currently operates 6 sub-regional bureaus staffed by law enforcement representatives operating from their respective regions. These bureaus are located in Argentina, the Ivory Coast, El Salvador, Kenya, Thailand, and Zimbabwe. The primary task of Interpol is to support police and law enforcement agencies in its 186 member countries in their efforts to prevent crime and conduct international criminal investigations as efficiently and effectively as possible. Interpol facilitates cross-border police cooperation and, as appropriate, supports governmental and intergovernmental organizations, authorities, and services whose mission is to prevent or combat crime. Interpol provides its member states and designated partner states 4 core functions. These four core functions are codified in the Statute of the Interpol, which have been ratified duly by all the member states. The 4 core functions are to ensure secure global police communication services, global databases, global data services, operational police support services, and finally, training and development modules. In the course of this module, you have understood what it means to have universal jurisdiction, how international criminal law has evolved through case law to use the principle of universal jurisdiction, and how there are organizations and states that support this development. Thank you.